Good morning, good afternoon. Welcome to this webinar. That's great to have you all here at this 4IP Council's webinar, which is entitled Digitize IP Content in the Metaverse, Fair Use or Infringement. My name is Axel Frazzini, and I'm the Managing Director of 4IP Council. I will be your host today. So, if you don't know what 4IP Council is about, here's a quick summary. We are a not-for-profit research organization, and we are focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. You can find on the website a lot of content, but here's a short list. We have plenty of free materials because everything that we publish is free of charge. For example, we have studies, we have summaries of relevant papers, we have recordings of webinars, we have podcast interviews with investors, entrepreneurs, and IP disseminators. We also produce easy to digest content such as the SME's Corner, especially tailored for non-IP experts, SMEs, and startups. We also have an area on our website called the IoT and Cellular Standards Made Simple, where you can learn about the benefits of standards and the Internet of Things across different sectors. I recommend to check it out. Then we have recently launched a new area called AI and intellectual property rights with guides, videos, papers, and interviews to help you to understand how artificial intelligence is revolutionizing the way we live, work, and create, but also the pressing questions raising about IPRs. So give it a look. Let us know if you have any feedback. It is just launched like a few weeks ago. And if you want to provide comments, please feel free to do so. Then, that's very easy. You can follow us on all the social networks, like such as X, formerly Twitter, LinkedIn, YouTube, and Instagram. Our handle is 4IP Council. There you can find about IP news, resources, interviews, and future webinars. But without further delay, it is my pleasure today to introduce our speaker, Dr. Ioana Lapatura. She is a lecturer in intellectual property law at the University of Leeds. She holds a PhD in law from the University of Nottingham. She undertook research in the areas of intellectual property law, blockchain technology, and fashion, for which she has been awarded a University of Nottingham School of Law scholarship. Ioana has been a guest lecturer in fashion law and technology at, among others, the Milano Fashion Institute, Brunel University London, Nottingham Trent University, and the University of Szeged. Her research interests include copyright, trademarks, and design rights, as well as IT law and the creative industries, with a special interest in the fashion, art, and glam sectors. A final remark for the audience: please do not hesitate to use the Q&A tool that you can find at the bottom of your screen to ask questions along the presentation, and we will take live questions at the end of the presentation. This webinar will be recorded and will be published tomorrow. So, Ioana, the floor is yours. You might be muted.
Can you hear me now?
Yes, that's good.
Okay. Thank you very much for the warm introduction, Axel, and thank you to the whole 4IP Council team, including Marta. I'm very pleased to be here, at least online today, to have a webinar on this very interesting topic. And also I'd like to thank those of you who have joined the webinar. So the focus is on the digitization and use of IP content as NFTs in the metaverse by artists. And we will effectively look at when those prima facie infringement instances would be covered by a defense under both copyright and trademark law. So to start off, I'd like to just highlight how copyright and trademark content has been the subject of artistic uses for years. And I'd like to start off with one of the most prominent examples where a trademark has been the content of an artwork by Andy Warhol, the Soup Cans by Campbell's in 1962. Which I'm sure you're all familiar with. And then over here I have another example, two artworks by Nadia Plesner, Der Furnica and Simple Living. So both of those artworks have a common kind of element, a malnourished child wearing a Louis Vuitton logo bag, sort of stress the contrast between the Western world and capitalism as opposed to other parts of the world and the problems they face, such as problems induced by war or hunger, such as in Darfur. So effectively getting into a conversation with the original, kind of trying to convey a specific message. And then we have some other examples where copyright content has been the subject matter of artistic uses. So the very famous Mona Lisa by Da Vinci, and then The Scream by Edmund Munch. So as you can see, we have some examples of some very colorful, cartoonized or other sort of different styles, different artistic styles, sort of examples of those artistic works. So all of those are examples of the exercise of artists' freedom of expression, and they often try to convey a specific message, as in the example of Plesner's painting, or enter into a dialogue with the original artwork. So such artistic uses can be the content of can be accepted from liability, can be covered by a defense under EU law. Coming now into the context of the metaverse, I'm introducing a widely publicized case here, which dates back to 2021, and it's been the subject matter of litigation in the US up until 2023. I'm talking about the case where Rothschild, a digital artist, minted and sold NFTs of the famous Birkin marks by Hermes. The case gained high publicity, given that this minting and selling of those NFTs was without authorization from Hermes themselves, and it has divided opinion as to what amounts to artistic use. So I'd like to start off by outlining the key process that we will be looking today, as well as the questions that the webinar will address. So the process that is typically being followed in this context is the digitization of a 3D subject matter, a real-world item, such as their Hermes bag, to two-dimensional form, and this involves exact reproduction, the digitization itself. Then we move on to tokenization, so taking that two-dimensional digitized version and converting it into an NFT. This process is else called minting. And then use, which is what we're going to particularly focus on today, use in the metaverse without consent by the original author or the IP owner. So the two key questions that the webinar is going to address is, first of all, whether the digitization, tokenization, and use of IP content in the metaverse could be regarded as infringement by an artist under trademark or copyright law. And we will particularly look at two case studies. and then whether any artistic use defenses could apply, under what conditions, and essentially to what extent a balance could be achieved between the interest of IP owners on the one hand and freedom of artistic expression on the other. So, the first trademark infringement case is the Hermes and Rothschild case that I've already briefly introduced to you. It is a US case where the digital artist Rothschild digitized, minted, and exhibited, and even sold around 100 NFT virtual handbags of an almost identical design to the iconic Hermes Birkin handbag, and selling them under the name Meta Birkins. So in this specific case, I will examine whether Hermes rugs could be infringed on the given facts from an EU trademark law perspective. And importantly, I'd like to highlight that both the Birkin wordmark is protected as an EU trademark, but also the three-dimensional shape mark of the bag itself is also protected as a trademark. And as we can see here, both the shape as well as the name, the word marks are at least similar, if not very similar. So in this particular case, we will be concerned with use and whether it amounts to infringement, and we will particularly look at the two claims that Hermes brought against Rothschild in the US through the European trademark law lens. The two trademark claims that were brought were for consumer confusion and then for dilution. So taking them, considering them in turn, the first one, consumer confusion, we will be looking at Article 10 to be of the Trademark Directive of 2015 to examine infringement. So first of all, the first requirement would be for the goods, for the signs to be either identical or similar. So over here we have Birkin versus Meta Birkin. So one could argue that they are very similar, if not identical, given the addition of the word meta, and then the rest is exactly the same. The second product of the test, however, would be problematic from a European law perspective, because on the one hand, the Birkin trademark is concerned with physical handbags, which would be under class 18 of the NICE classification, whereas the Meta Birkin would be the virtual NFT handbags would be classed under class 9. The newly introduced class for downloadable image files or downloadable digital image files authenticated by NFTs. So at the time of litigation, it's important to know that Hermes had not yet expanded their presence into the metaverse, nor had they expanded their trademark portfolio. So that would probably be the key issue for failing this claim, given that the third part of the test would likely be easy to establish, because likelihood of confusion or association, because under the global appreciation test, the average consumer would likely be misled as to trade origin of the goods, and so this would also be in line with the US test and the US finding. Moving on to the second claim, dilution and unfair advantage. In Europe, we would be looking at Article 10.2c of the directive. So again, we would have to look at the signs, whether identical or similar, and we have already established that this could be satisfied. Secondly, identical, similar, or dissimilar goods, just because we're dealing with a famous mark, a mark with a reputation in the EU territory, when talking about the Birkin trademark. So over here, we would bypass the difficulty of the previous claim. So the test would be satisfied even though the classes of goods are dissimilar. And then we'd have to look at unfair advantage or detriment to the trademark's distinctive character or repute, given its popularity. So, in respect of that particular prong of the test, the US court pointed to dilution, which is further reinforced by the fact that Hermes had not yet expanded their business presence into the metaverse, but also because Rothschild was selling multiple digital bags with a similar design and a similar sign at a previous pricing that was also similar to Hermes. So the US judgment was concluded in February of 2023 and Hermes won. And this would likely be the case under European law. However, if we pause for a moment and consider the potential defense, the artistic use defense that Rothschild tried to argue, Rothschild was essentially arguing that these Meta Birkin digital handbags were an artistic commentary on consumerism in the digital age, and also on the fact that Hermes does not align with the fair free movement in the fashion sector due to using real leather into their goods, into their bags. So, from a European point of view, when looking at recital 27 of the Trademark Directive, it stipulates that use of a trademark by a third party for the purpose of artistic expression should be considered as fair so long as it is in accordance with honest practices in industrial and commercial matters. So the key question here is whether this honest practices proviso could be satisfied. At the EU level, we do have some clarification as to that. Before that, out of the list of potential defenses for trademarks, Article 14.1c of the directive and the so-called referential use defense would be the most relevant on the given facts, because it refers to use of elements of the earlier trademark for identifying or referring to goods as those covered under the trademark, when considering versus Meta Birkins. So this particular referential use defense has undergone some reform, and it does now cover parody, so its scope has been expanded, and certain academics, including Seth Leben, have argued that using a trademark to symbolize and criticize policies of the trademark proprietor may fall within the scope of the referential use concept. So, if we try to apply this in the context of Rothschild, given that his aim was to divert the Birkin marks from their original meaning and to communicate a message that relates, for instance, to the fair free movement in fashion, this could potentially apply so long as it also abides with the honest practices proviso. What does it mean in practice, however? We do have clarification from the European Court of Justice on the meaning of this proviso under Gillette and LA Laboratories, where the court has listed a number of uses that cannot be regarded honest. So the first two are particularly relevant for our analysis. Uses that give the impression that there are commercial links with a trademark. So on the given facts, given that a very similar design and a very similar sign were used by Rothschild to sell those bags and use them in the metaverse and in the real world, essentially, that would probably satisfy this prong. Secondly, uses that affect a trademark's value by taking an unfair advantage from its reputation or distinctiveness. So, in this particular case, given that dilution was being suspected, and due to the economic activity involved in the use, because Rothschild sold many bags and made a high profit from the sale of the Meta Birkins, and this would also likely be satisfied. So it's almost clear that the use in the present facts would not be considered honest and therefore not fair, and as such defense would likely fail under EU law. Now, moving on to our second case study, where we examine infringement under copyright law. The case study that I picked is VEGAP and Mango. VEGAP standing for a collecting society organization for artist rights in Spain, and Mango, the fast fashion company. So the case was concerned with 5 in-copyright paintings by Miro, Barcelo, and Tapies, Spanish artists, which were digitized and minted into digital NFT wearables by commissioned digital artists without authorization from the rights holders, in order to commemorate Mango's expansion to the US market. So as we can see on the left-hand side of the screen, that's a snippet from the New York opening, the New York store's opening of Mango, where they side by side put the original artwork and the NFT digital wearables on the screen. So this is particularly Miro's painting and the accompanying NFT wearables. So obviously this involves the right of reproduction. First of all, because the digitization of those artworks involves exact reproduction, but also because post-digitization, the final creations essentially carried a substantial part of the originality of the earlier artworks. And also, more than that, those artworks were used without authorization by the painters in the metaverse. And this could implicate the right of public communication because they were publicly exhibited at Mango's virtual store in the metaverse platform Decentraland. So, excuse me. So, Mango, interestingly in this case, had physical ownership of the paintings, and there is a Spanish national law under Article 56(2) of the Spanish Intellectual Property Act, which stipulates that the right of exhibition lies with the owners of physical artworks without the need to seek for authorization by the original artists in those cases, unless it was contractually ruled out when the actual paintings were acquired by Mango, and this is not the case on the present facts, or when that use in the metaverse could harm the reputation of the original artists in some way. And in this case, the Spanish court rejected that, as well as any sort of moral rights violations. So based on that exception, that overbroad exception of Spanish national law, the digital works exhibition in the metaverse was permissible, and there is no infringement to the right of public communication. However, the Spanish court, acknowledging that infringement of the reproduction rights was at play here, by also calling those NFT creations as derivative works, they considered potential defenses and tried to assess whether those derivative works could be regarded as transformative. So there was a lack of a national defense for artistic use in Spain, and so what the Spanish courts tried to do was to apply the three-step test by the Berne Convention, but truly follow the U.S. fair use principles. Sorry. So factors such as the purpose and character of the use, nature of the work protected by copyright, the amount and substantiality of the copied portion, and the effect of the use on the value of the copied work or its potential markets were the determining factors in the court's analysis. So, the Barcelona court ruled that a number of things. First of all, that the exhibition of those works were non-commercial in nature because they were merely for the purpose of commemorating Mango's new store opening. They further ruled that there was no evidence of an increase in sales on Mango's products that resulted because of that activity of those digitization and minting of the artworks. They also argued that while the physical artworks were sold and they were used for commercial purposes at the Mango stores themselves, the physical stores, the digitized versions were created for secondary reasons, again, for commemorating the store opening and the expansion of Mango to the US market. They further ruled that the new works were not marketed nor offered for sale. So the NFTs could not be purchased by anyone. So they concluded that this means that they did not interfere with the value of the original artworks. And therefore, they concluded that they ruled in favor of Mango, and they ruled the defense of fair use, or in the Spanish legal terminology, harmless use, was established in 2024. Now, I would be happy to share some further thoughts on that judgment during the Q&A, but just a very small note before we wrap this webinar up. This activity, so this is one way to see things. On the other hand, this activity could be viewed as a brand campaign with a for-profit motive because Mango decided to sort of commission those digital artists. So there was some expenditure there. And so this could point to the commercial character of the use, and it could also be an attempt to gain brand visibility because the metaverse, it has a global audience. It is used by hundreds of users. So the non-commercial nature of this activity that the Spanish courts found is not necessarily what would realistically be found had the activity taken place in the real world. So in conclusion, and before addressing any of your points, let me summarize the following. First of all, with regard to digitized and tokenized IP content, artistic use defenses might apply, but their scope should not necessarily be extended just because the activity takes place in the metaverse. And in the case of Rothschild, we saw, for example, that trademark scope encompasses uses in the course of trade, uses that affect the trade origin function, or that dilute the distinctive character and reputation of an earlier famous mark, and that was clearly the case on the given facts. On the other hand, in the case of Mango, copyright scope can be limited where artistic use is truly for the purposes of conveying a specific message or entering into a dialogue with the original work. So these are all in the context of freedom of artistic expression. However, if those tokenized copyright works are to be sold, So if they are to be commercially exploited, this would likely be outside the scope of the Berne Convention and its three-step test, and it would be less likely that a defense would be applicable in such context. So with that, I would like to conclude and thank you for your attention. If there are any comments or questions, I will be happy to take them. Thank you.
Thank you so much, Joanna. That's really appreciated. I like the way you took the cases, you tried to explain in a very neutral manner. But now
Thank
that's
you.
the time for the Q&A. So I guess we will learn more about your personal opinion on some
Absolutely.
cases. So the first question that I received is, do you think VGAP versus Mango is a good precedent? Should it be followed in the future?
Thank you very much for the first question, Axel, and for your kind words. I wouldn't say so. I don't really think that it is a good precedent or a precedent that is going to be followed. And equally, I don't think that it is going to make it easier for artists to sort of establish a defense in that context and succeed in claiming a transformative use. Because to me, and as I hinted during my presentation, Mango's activity seems like a commercial PR strategy aimed to attract brand image, brand goodwill, recognition. So the transformative character is equally questionable. Because if we stay for a moment on the artistic message that was trying to be conveyed, and I didn't have the time to explain that in my presentation, but essentially, in the court, in this case, Mango and Punto SA, sort of the bigger company that owns Mango, they essentially said the artistic message that was trying to be conveyed related to Mango's owner and his three passions for fashion, for art, and for the Mediterranean heritage. That really, to me, doesn't seem like a complex artistic message, rather than and there are other cases in Europe, for instance, um, I'm thinking about a French case from 2021 involving Fait divers, a sculpture by Jeff Koons. And there was a much more complex artistic message that was trying to be communicated by the derivative work. But the court said, well, that's not enough for it to be transformative. So I think the fair use doctrine was applied too leniently, and I do think that greater emphasis should have been placed on the actual use of the works in a commercial context that was overlooked, and that would not normally pass the European standards of the defenses.
Very clear. Thank you. And the other case, the Hermes versus Rothschild, is a US case. If that had been decided under EU law, do you think that there would be much of a difference or not at all?
Well, I don't think that there would be much of a difference, at least in terms of its outcome. I do think that under European law, the claim would have succeeded, at least under dilution. But the biggest difference, I guess, would be in terms of the defense itself. Because in the US, there is the old Grimaldi test. In Europe, we have a lack of parity as a defense for trademarks, and we have to comply with the honest practices proviso. So things would be quite difficult for Rothschild. And despite his sort of arguments, the fact that the use was commercial and high profits were made, I don't think that he would succeed if the case was decided in Europe. So I don't think that there would be a different outcome overall.
Okay, very interesting. So it leads us to, do you think that we need an IP regulation for the metaverse? Or is there any metaverse regulation so far?
Thank you. That's a very interesting question because, on the one hand, we don't have any metaverse regulations so far. So the only thing that we have is a strategy that was published by the European Commission in 2023. It is the strategy on the governance of virtual worlds and Web 4.0. So we don't have exact guidelines. However, we do have some values that the future regulation of metaverse platforms and the metaverse overall should abide by. So, those include, for instance, respect for fundamental rights. This means respect for freedom of artistic expression, but equally respect for copyright, which is also a fundamental right. So we also have a guiding principle of accessibility to the metaverse, to businesses, to all stakeholders, to the public. So on that note, there is no specific meta IP regulation in the metaverse other than those guidelines. And frankly, I do not think that we do need any specific IP regulation for the metaverse. I think that the existing IP frameworks are capable of adapting to the challenges and essentially use of IP content in the metaverse can be approached comparably with use of IP content in on the internet for many years in the past. So, for instance, in respect of establishing infringement or defenses, I think that the existing frameworks are more than capable to adapt. One area that perhaps could be a little bit problematic would be enforcement of IP rights. And the key reason is that metaverse platforms, some of them are centralized, but some others are decentralized and they run on the Ethereum blockchain. One of them is Decentraland, or at least that's what's been shared about it online. So if this is decentralized, things become much more challenging for rights holders. If it is centralized, then we can have filtering technologies in a similar fashion to YouTube's Content ID, where content is being filtered and then rights holders can send notice and takedown requests. So that can make things a little bit better for rights holders. But it would solely depend on the type of metaverse platform.
Okay. One question that is more on the two questions that are more on the practical side. So is that true that you can edit or apply changes to an IP protected work and not infringe, even if you are not an artist? Or do the defenses only apply to artists?
That's a very good question. I do realize that my webinar was focused on artists, freedom of artistic expression, and so on and so forth. But absolutely, if you are an online user, you can absolutely take advantage of defenses and they can apply in your situation. For instance, if you experiment with any IP content for non-commercial purposes, let's say you're making a collage, you're at a fashion school and you make a collage of branded bags with logos and everything. If it's for a school project or a university essay or anything, it could be covered by the private study or research exception under Article 5.3 of the InfoSec Directive. I also am thinking about the age that we currently are in, so the AI age. So even if you experiment with AI tools, and many of us do, you may be editing or painting. Remember the Mona Lisa and the variations of it at one of my first slides. You could still be evading a liability if you use it for non-commercial purposes. You can experiment with it, you can engage with the content, that's all permissible. The risk of liability would only increase if you decide to do something with it in a commercial context. So for instance, you digitize an artwork and you sell it as an NFT. equally with AI outputs, depending on your contribution, you could be risking infringement.
Okay, but then if the defense fail
Mm-hmm.
or don't apply, who will be liable for infringement?
Well, I would have hoped to say that it's a very clear-cut answer, but I would suggest the first thing for any user to do is to just check the terms of service, because every single platform, including AI platforms, because I mentioned the AI tools, they have different terms of service. So it would basically dictate whether it is the user, the individual, the artist that is liable, or whether it is the NFT, the Metaverse platform, the AI platform. And in the context of Metaverse and NFTs, there are NFT marketplaces, there are other platforms that are just hosting providers. So there's a lot of differences there, depending on whether they sell or they just host or they have any control over the content. That could dictate some things. So it would really depend on the terms of service.
Okay, I can combine two questions in one. So that's what can IP owners do to enforce their rights? And another one that is related is, will you advise trademark owners to extend their protection to include class 9 going forward to get a better position just in case infringement in the metaverse will occur?
Okay, thank you very much. So in terms of enforcement, again, I hate to say this, but it would really depend on whether the platform would be centralized or decentralized. And fingers crossed, if it is centralized, the rights holders could issue notice and takedown requests to the platforms to remove infringing content. And they could if they could pinpoint to a specific individual that's misusing their work. So let's say it is an artist, or an artist's work is being used by, I don't know, some other company. And we have seen that, for instance, a lot in the fashion sector, where fast fashion brands and chains kind of without authorization use the work of small independent designers and they launch it in their collections. So a cease and desist letter could be effective in that context as well. There are some extra legal enforcement methods. For instance, before resorting to settlements, sometimes publicly shaming on social media, the infringer could also be effective. It has some negative effects, of course, because you could get excluded from future collaborations or future jobs, and it could affect your career if you're especially a small brand or a designer. But these are some of the measures that you could take. In terms of registration for Class 9, for goods on the metaverse, even if you only have a physical presence and you have not expanded your business into the metaverse, my advice would be to, yes, register and register as early as possible, because if, for instance, the Birkin handbag did not have a reputation, which means that they have extended protection against non-similar goods, so bags versus NFTs. Well, one thing that could go wrong is that Rothschild could establish a reputation, a brand reputation in the metaverse. So if then Hermes wanted to expand into the metaverse, anything that was similar to Rothschild's Meta Birkins, so Firkins, Turkins, Merkins, it would be Hermes that would infringe, because there would not be a registration in respect of those things. And this is how larger brands have a better protection due to having a reputation. So they have this extended trademark protection against dilution. With smaller brands, I think it is very important to sort of register to class 9 as early as possible. I'm not implying that this is absolutely fair on the part of small designers because it makes them incur extra expenses. However, it is how things are. And well, it makes things more certain from a legal perspective for them and for their portfolios.
Okay. Um, so do you think that we don't need to have a separate trademark registration requirement for goods in the metaverse, or is that necessary?
Yes, so uh, that links again to my previous answer. It is necessary as things
Okay.
currently stand. I don't, so it adds on legal certainty, but on the other hand, it creates additional costs for rights holders and it sort of creates more unequal position between larger brands with a reputation and smaller brands with no reputation. If I just give you an example of Hermes, we said that on the claim for consumer confusion, because the goods were dissimilar, the claim would have failed. So, just because they had this reputation, they were able to rely on dilution and have this extended trademark protection, even in the metaverse, even in a market space where they don't have any trademark registrations, and they didn't have them at the time. However, if we compare it to small brands with not enough goodwill, they would have just failed the consumer confusion claim, but they would have no other option. So they couldn't really enforce their IP elsewhere. So that's the unequal position point that I'm.
Okay.
Uh,
But in case of infringement by a decentralized platform, decentralized metaverse platform, how can IP owners enforce their rights? Who is the defendant?
So again, it would have to be the platform, and there would have to be a categorization of what kind of platform it is. Is it hosting the content? Is it selling the content? It would solely depend. But things get complicated in respect of blockchain technology. So if it's running on the Ethereum blockchain, such as Decentraland, for instance, and it's completely decentralized, um, everything that gets recorded into the blockchain is immutably recorded. And how exactly content removal could be carried out, that's a big question mark for the industry. So that's a point that this future metaverse regulation should really pay attention to. Things would be
Okay.
tough.
Yeah, I can imagine how complicated that would be. But there is a big debate on copyright and generative AI. Do you think that defenses can apply to AI output?
Yes, that's another very good point. Especially now, because I'm talking about art, I'm thinking AI generated art, and it may contain a substantial part of an earlier copyright work, for instance, either because the AI model may have engaged in text and data mining, and that's so the copyright work was part of those data that were mined, or because, and this is often the case in the creative industries, the AI user, they take content, including copyright works, they use it as input data, so they feed it into the AI model and to sort of experiment, and the outputs then can give them inspiration. This is often the case in fashion, art. So the output, the AI generated output, may actually bear a substantial part of the originality of the copyright work, and through either of those routes. So defenses that could apply, first of all, parody. So under the InfoSoc directive in the copyright regime, we do have a parody defense. So as long as the AI output was evoking the earlier work, so there needs to be this dialogue with the earlier work. and the purpose of it was for a mockery or for humorous purposes, it could succeed. There is sorry, there is also a big discussion now around the exception of pastiche. That's the defense where it may apply when you create something in the style of. And this has a very practical significance because, well, many AI users ask in their prompts ask for I don't know, this artwork in the style of Picasso or in the style of Mona Lisa. So it can be in the style of a specific copyright work or an artist or a time period or a style. So currently, we've had a referral to the European Court of Justice in Pelham number 2. That's just a few months ago. So we are awaiting the interpretation of this exception, but it could be very, very useful, especially for users of AI.
Okay. So do you think that existing laws should apply as normal in the metaverse?
Thank you. So, I did say earlier that I do think that they are adaptable to the metaverse. Now, the question is whether they should apply as normal in the metaverse. I do think so. I don't think they should apply as normal because infringement taking place in the metaverse can be just as harmful as in the real world. It can harm the interests of the IP owners because there's a global audience. We don't know how large it is, but it's still any online user can access it. So why should we treat it any differently from the internet? First point. Second of all, it could deprive original authors, creators from an income stream if infringers are free to do whatever they want to do. And Venga and the approach in Vegap and Mango, I think it's an example where the exceptions framework was applied very leniently, very flexibly. They did adopt fair use, which is a US doctrine, and it's generally a little bit more lenient compared to the EU system that we have. But just because something happens in the metaverse, that's not a good enough reason to just apply these standards more leniently. And it does blur legal certainty in the end.
Okay. And how to find a competent court for infringement in the metaverse? Where does the infringement occur?
And so I think this question is pointing to this sort of global nature of the metaverse. So that's a different so that's a different question. That's a complicated question of international law. I do not have the answer to that. Depending on where the user is, or perhaps if we could pinpoint where the NFT was created and whether there was, if it's a trademark involved, whether there was any targeting, any audience in any specific jurisdiction that could have played a role in jurisdiction. But this is not really something that I can answer, and I'm not really an international lawyer either.
Okay. I think you already answered this question, but just to make sure, are research or teaching regarded as a non-commercial use?
Yes, so private study or non-commercial research is covered under Section 5.3 of the InfoSoc Directive. Of course, research can be commercial, so the non-commercial research can be covered by the defense, correct?
Okay. And final question before we move on. Do you think that there is enough protection for artists who appropriate trademarks?
Well, one thing I have to say is that things are not equal compared when artists appropriate trademark works versus copyright works. Because in terms of trademarks, it would be more difficult for them to succeed in the defense for a few reasons. As we said earlier, there is no express parody defense, and this would be so referential use is the closest thing that we have in respect of that. Secondly, the test for infringement, so confusion, dilution, especially when we talk about famous mark. It's very difficult for artists not to cross this fine line, not to, because it's, so in the course of trade, it's very difficult to not cross that fine line. And and lastly, the honest practices proviso. As long as Rothschild was selling those things, so there was commercial activity involved, and dilution was suspected in that particular case, again, it's very difficult to succeed in the defense. Whereas with copyright, parody is a recognized permitted use under the InfoSoc directive. So overall, it's not black and white. However, there is a better protection in that respect for copyright appropriation as compared to trademark appropriation, in my opinion.
Very good. Thank you so much. I think, this is a topic that is growing. We should see a lot of maybe new regulation, new laws, or the system will have to adapt. But you provided a lot of information, and thank you very much for sharing your knowledge. So this is the first webinar on this topic, and I believe that in the near future we might do another one. But we are getting closer to the end of this webinar, and I would like to just announce the next webinar, which will be the big steal, ideology, interest, and the undoing of intellectual property with Professor Jonathan Barnett. It will be on the 28th of May. You can already register on the 4IP Council website. And I hope that you will attend, because that's where he will present the ideas of his recently published book, The Big Steal. We are in the process of publishing on the 4IP website summaries of some of the chapters of the book. You may want to have a look before the webinar, and if you don't, let me just say that during this webinar, we'll cover many different topics. You can flash the QR code to directly end it up on the registration page. Finally, we received several times the same question. Yes, the recording of the webinar will be made public on the website. The slides will also be published. So everything should be fine by tomorrow. Thank you again very much, Joanna, for
Thank you very
coming
much,
to 4IP
Axel.
Council.
Thank you very much.
Thank you, and bye to all of you.